The paper I'm presenting to you is the outcome of a quite long research I've been doing for the last year or so. It's a research which was prompted by the question that Dalia, Richard, and Geneviève were in fact raising about the fragmentation of labor law in general. And in particular, I was interested in interrogating some basic principles of labor law, some of its very foundations. And within these principles, I was intrigued by the functioning, by the meaning and functioning of the favor principle or the favor rule. Because we know that coupled with the principle of non-waivability or non-derogability of labor law, the favor principle has constituted one of the pillars of labor law. It is what we teach our students since decades, I would say centuries. And I was intrigued by the fact that it seemed to me that more and more this principle is losing its own meaning. For sure, given a very general definitions of favor principle is already difficult. But my starting point was to take a minimum definition. And we could define the principle of favor as the principle which gives priority to one specific source when two or more sources are conflicting. By nature, therefore, another source is going to be superseded. Well, then I started to work comparatively on several legal systems, some European legal systems, and then the UK and the US. And I quickly realized that this favorability principle does not work the same across the board. My starting point, and I will be quick on this, my starting point was a practical case decided by the French Supreme Court in 1988. It's an interesting case because literally the French Cour de Cassation was able to resurrect a collective agreement which was concluded more than 20 years before, and which was a little bit set aside by the first and second instance judges. And this is a case where, in fact, the Cour de Cassation held that the source which prevails is the one more favorable to the employee. End of the story. But the case as such triggers at least three different scenarios where the principle of favor can play a role. First of all, the relationship between the law and collective agreements in general of all levels. Secondly, between individual employment contracts and the law or collective agreements. And thirdly, between collective agreements of different levels. So I will now very briefly go on the three scenarios. Now, when it comes to the law, so the contrast, possible contrast or conflict between the law and collective agreements, I must say that life is easier because there the principle of favor comes as sort of a corollary of the principle of non-waivability. Why should we allow collective agreements to derogate impeius than the law? Well, we should not allow this in general. Particularly, we have seen that this principle remains a founding principle of concerning the law itself, concerning the value of the law itself. Why? Because the law itself is non-derogable, non-waivable. Here, the only thing I would like to highlight that we have some differences between continental European countries on the one hand and the US and the UK on the other hand, because in those contexts, in those second contexts, we don't have such a role. Second scenario, between collective agreements and individual stipulations. Well, there already the principle starts to become more complex because it might be that in some countries the principle is admitted, however, depending on the country. It can also be that collective agreements can derogate to imperieus, so to say. So it deals in this second scenario with the normative effect or normative efficacy of collective agreements. But for sure, the most, I would say, controversial and to be discussed scenario is the third one. And it's a conflict between collective agreements of different levels. Why is it more complex to discuss this case? Well, first of all, because we have, comparatively speaking, many different systems of industrial relations. And this is clear when we simply take the perspective of distinguishing from single channel and dual channel countries. By single channel and dual channel, meaning the channels of representation. You know that, for instance, Germany is the prototype of the dual channel. Italy used to be the prototype of the single channel. Most countries are nowadays mixed channels. But why is it relevant? Because the contrast between the two channels is typically regulated differently, whether we are in a country where the trade unions run the two levels, or we're in a countries where we have trade unions on the one hand and works councils on the other hand. Then, of course, the comparative exercise is particularly difficult because the systems themselves of labor law are different, and because the post 2011 EU economic governance decisions that have been taken in the European context had a very disparate and very diverse effect across European countries. Therefore, we must be careful in going too far with this comparison. But it's clear, and you see this a little bit from the slide, it's clear that some countries, I'm sure that Nicolas already discussed thoroughly about the French case. So some other countries, for instance, Italy, for instance, Spain, have suffered the influence of these EU economic governance decisions that were led to decentralize collective bargaining and therefore give priority to the second level of collective bargaining, the enterprise level or territorial level. Why is this problematic? Well, it's problematic precisely because at second level collective bargaining, the interests at stake play very differently than sectoral level, therefore than national level. And because you may risk, you as a legal system, you may risk to lose consistency when you allow derogations without any limits, any specific limits at second level collective bargaining. You typically have that kind of fragmentation of labor laws, so fragmentation of the system that was set in the introduction of this section. So what could be a conclusion? Well, I started playing a little bit with the general theory of law and check whether a principle which is so much disarticulated, so much fragmented, remains a principle. Can we call it a principle? And probably the best distinction that I found was the famous one by Ronald Dworkin between a rule and a principle, where a rule is a yes or no thing, in the sense that either a rule is applicable to a certain circumstance or it is not. Whereas a principle has a more general meaning, has a more orientative meaning. And therefore, in this sense, it might be interesting to see whether, well, I found interesting to see whether the favor principle is in fact still a principle or has rather been degraded into a rule. But even when we check whether it's a principle or a rule, and we do that in the light of the general framework, we see that even in the European Union, the favor rule is set, but only in certain circumstances. and it doesn't really play any role substantively. So it does play a role when we have European directives, so in the relationship between the member states and the European Union, but it does not play a role on the substance of the rules that are established by the European Union. So to conclude, since I'm already in my 10 minutes, are we sure that a principle which is then degraded into a role is still a principle? And my answer is probably not. Probably not, in the sense that more and more labor laws are turning into dispositive provisions, what Alain Supiot named dispositive provisions, and it's dismissing its functional, its fundamental role of establishing jus cogens, so of establishing principles that cannot be derogated even impious by the parties. So that's more or less my conclusion. For better understanding, I would say let's wait the publication of the paper. Thank you so much.